Hi everyone, thank you for showing up for this presentation, Evaluations with Survivors of Domestic Violence. My name is Gloria Greenfield. I am the Director of Immigration Advocacy at Sojourner House. And that's me. This is the first time I ever record something, but I figured to give you a face to the voice. We usually do this in person, and it's a great opportunity for me to meet a lot of the volunteers that participate in this amazing partnership that we have with the Sojourner House and Brown University. I thank you on behalf of all the victims that you are willing to serve, because sometimes your assistance and your intervention means a great difference in their lives. And I have got a few cases granted because we had a great evaluation to go with it. I've been with Sojourner House for almost 10 years now, and I have run the Immigration Advocacy Program since 2012. I have been working with Sojourner House in different capacities, but since 2015, I've been doing this full time. We have a program of about 2.5 person in the program, and I am the director, and I represent a lot of the victims in their immigration cases before USCIS and also before the immigration court in Boston. I am going to try to make this the best possible. It's very strange to do this without an audience, and I'm going to try to think ahead of what questions you might have, but at the end you're going to have my contact information, and you can always reach out to me if you have specific questions or if you want to learn more about the work we do. So let's start. These are the objectives. We hope that by the end of the presentation you understand a little better the dynamics of domestic violence and how it's different in the immigrant population or mixed status families or all undocumented families, and how is it different from someone who was born in this country and who doesn't have any immigration issues. We are hoping that you learn to identify and serve undocumented victims and make the proper referrals if that's possible. And I think the most important, this is what applies to you the most, is to learn about the possible immigration relief for undocumented victims of domestic violence. We at Sojourner House serve victims of domestic violence, sexual assault, and human trafficking. And I think for the most part, the cases that we refer to BHRAC are for VAWA cases and also for human trafficking cases. And we'll talk a little bit more about that as we go. So let's start with the basic definition of domestic violence. There's many definitions, but this is one that, in my opinion, puts it in perspective and helps understand. And this is actually a definition that we use with our own clients, because a lot of times they don't even realize they are in abusive relationships. So it says, when one person in a relationship dominates choices and decisions using a variety of tactics and escalating patterns without regard of the needs for the others in the relationship. And as you can see, the word tactics in an escalating pattern is highlighted, because these are a lot of the behaviors of the clients that victims are unable to identify, because either they have been experiencing it for so long and they have normalized abuse, especially if they come from countries where domestic violence is the norm, and this is, generational issues that they have learned from their mothers and their sisters and aunts, and they just don't understand that that can be construed as domestic violence. So why is it so different being an immigrant or undocumented victim? Data shows that victims who are undocumented or immigrants sustain more severe physical and emotional consequences of abuse. And this is for several reasons. One, because they are more vulnerable to crime. I have a specific slide for that. And they stay with the abuser longer. We have clients that have been with the abuser for 7, 10, 20 years. And the reason they stay is because they have barriers that are very difficult to overcome. To give you an example, one of the main barriers might be the fear of deportation, or the fear of contacting the police, or the abuser has threatened to, I don't know, get DCOF involved, or get the children deported, or get her separated from the children. So, and just as a caveat, I am going to refer to the victim as she and the abuser as he, but we know that this happened to any gender, any socioeconomic status. It's just for the sake of the presentation, it's a little easier that way. We do have specific male identifying victims programs. We have a shelter for male identifying victims. In my program, we serve a lot of men who have been victimized by their abusers, so who happen to be a female. So I just wanted to make that clarification. And also, immigrant victims usually have fewer resources available, because when you're undocumented, you don't qualify for food stamps, or you don't qualify for the cash assistance, or even health insurance. So contrary to popular beliefs, people think that anybody can come here and access benefit. That is not true. Even after getting a green card, a lot of people are unable to access public benefits because there's a bar. And fortunately, a lot of those public charge, the public charge rule doesn't apply for victims of domestic violence if they qualify for a specific benefit. Okay, so in here you can see the power and control wheel. Maybe some of you have seen it differently, but this is specific for immigrant victims. And in the top, it says for immigrant women, but this happens for people of any gender. A lot of the times, these are some of the behaviors and strategies that the abusers use to maintain the power and control over their victim. You can see, you can read, I'm just gonna go briefly over them. They use documentation in order to maintain the victim control. They either hide, destroy the documents, or they withhold filing paperwork for them. Just to give you an example, someone who is applying for a family petition, they can expect the green card within a year. And for the most part, abusers who have the ability to file for petitions for their spouses who are also their victims, the average for them to file is about 4 years. So these are 4 years that the victim is without any documentation or without any benefit, and they do it in order to control. Abusers often isolate the victim, and this is usually the #1 sign that the victims are able to identify. They prohibit them from speaking to their family in their home countries or here, or they don't let them go to church or get a job or go to school and learn English. They use the laws and regulations against them. A lot of time victims go by why their friends and family think it's the right solution for their case. So I get a lot of clients saying, well, I didn't get help because my so-and-so went through the same situation and they got a deportation order, or that it didn't work out for them. So they think because it didn't work out for someone else, it wasn't going to work out with them. Or the abuser might be like, no, they're not going to listen to you because you're undocumented. I have rights. I'm a citizen. I have more money. Whatever the reason may be, they're going to use the laws against them. And unfortunately, immigration law is one of the most complicated laws there are, and these victims don't have the information that they need. They don't know where to get services or who to ask. And also, unfortunately, there's a lot of people out there who portray themselves as attorneys, or they call themselves notarios, and they give wrong legal advice and usually put their cases in danger. The abusers also, like I said before, they might deny their residency paperwork for them. They use the children and family against them. They threaten to take the kids away because, I'm a citizen and a judge is going to give me the custody because you're undocumented. All right, so let's go forward. This kind of puts together what we were just saying. These are some of the tactics mostly used by abusers to control their victims. They isolate, they monitor, they create shifting realities, meaning, it's not that bad, you're just super sensitive, or, you're crazy. They manipulate the feelings, they attack the confidence, and they do all this to maintain the status quo. All right. This is a graphic that shows how the cycle of abuse usually happens in a relationship. You might have seen this before, where the cycle of abuse usually shows 3 stages. Usually what it shows is the tension building, incident, and calm. But I like this graphic better because it shows a third stage that it's what it's going to make the victim more susceptible to further abuse. Usually when the abuse happens, there's a lot of tension. Victim feels like they're walking on eggshell. They don't know what to say or what to do in order to maintain the calm in the home. And then something happens, the incident occur. It can be, verbal, emotional, physical. There's going to be a lot of threats, intimidation, and then this is the interesting part. There's going to be a reconciliation stage, and this is usually where the victim becomes more vulnerable to the abuser, because it's a lot of the compromising is, the abuser apologizes and then says, well, if you quit your job, I wouldn't get like this, or if we move out of state, this is not going to happen, or if we have another kid, this is, this wouldn't happen. And what they do is they use a lot of different tactics to make the victim accept that this is their situation and to believe that the abuse is not going to happen again. But that is not the case. Usually there's like a little calm stage, and they might think, things are fine and we're moving forward with our life, and then the whole cycle starts again. And all this does is it hides the cyclical nature of the problem. And a lot of, we have a lot of victims saying to us, well, it's not bad all the time. And when we have the clients write declarations, and I'm going to talk a little bit more about this, when the clients have to write their declarations for immigration, they usually at that moment realize, oh my God, I didn't notice that this was the pattern. Like, they start seeing that there's a lot of bad and a lot of tension, but there's also a lot of good and a lot of, charmness and a lot of good situation. And that's what usually keeps the victim trapped in that relationship. As a result, obviously, there's going to be a lot of victim blaming by the abuser, by the victim's family, by their community. A lot of these victims come from societies where domestic violence is a family matter and nobody should intervene. So by seeking help, by calling the police, by trying to get assistance, they are bringing shame to their community, and that brings a lot of victim blaming. When the victim is unable to get help, well, the offender gets away with it. They avoid the consequences. They are not, they're not held accountable for their actions. And this empowers the offender, and the victim is going to feel more marginalized. If there are children involved, there's always going to be a risk of DCOF getting involved, and this is sometimes one of the scariest situations that undocumented victims may face. I have seen cases where DCOF has been called by the abuser saying, the mother is a drug addict, or the mother is neglecting the children. And these are bogus, for the most part, these are bogus accusations, but DCOF has the duty to investigate. And this is just extremely scary for these victims. And it's also detrimental to their case. I mean, yes, a lot of these allegations are dismissed, but still it's in the record. And these are things that we have to explain to immigration that was part of the abuse, and they are easy to overcome, but it nonetheless is very, very scary for these victims. And this allows the offenders to commit more crimes against their victims. And the impact on the victims, it's going to be a lot of self-doubt, blame, confusion, anger, trauma. And the sad part is a lot of these victims, especially if they're undocumented, they're unable to get any type of therapy or counseling because they don't have the health insurance. So they have to go without these services, without, having someone to help them cope with their fear, with their anger, with their trauma, because they don't have the resources to do it. So we do have, at Sojourner House, we do have clinicians on staff, and we're about to hire a bilingual clinician, which helps, but I mean, there's only a couple of people, and we now have waiting lists on people wanting to receive therapy, and it's very, very challenging. There are other agencies that are providing therapy, but again, for the most part, these programs have waiting lists. We are extremely lucky that we have BHRAC providing these affidavits, these evaluations, because before we we found BHRAC, these clients were paying anywhere between $1,500 to $3,000 for a psychological report, because they knew this was the difference between getting their case approved or not. So they saw it as a necessity. And it's so sad to see these people making minimum wage and then coming up with this kind of money to improve their chances in their case. That was just, a little extra information, but that's why we are so thankful to have this partnership, because one, we're saving the clients a lot of money, and two, you have it in writing, in paper, all this impact that the views is having on these victims, and that is going to help the officer who's evaluating the case and making a decision. Is going to help understand the context of the situation. Okay, let's see next one. So this is a slide that I like to emphasize because it shows the vulnerability of these immigrant victims to crime. And I mentioned a few of this, but we can reiterate this. There's a lot of language barriers. I mean, a lot of police departments now have Spanish-speaking officers, and they might have even Portuguese-speaking officers, but not everybody who is undocumented speaks only English, Spanish or Portuguese. We have victims from Asian countries, and it's so hard to find interpreters. And, when you don't speak the language, it's going to be hard for you to access services and to, or to get help or to get assistance or even get a consultation anywhere. So language barriers is a problem. The lack of understanding of immigration laws or U.S. laws, like I mentioned before, is going to be a huge barrier, because usually the victim believes what the abuser wants them to believe. There's fear of deportation, fear of seeking benefits. A lot of the victims that are undocumented, they're always going to have this fear of ICE intervening in their life and getting arrested by ICE or getting in front of a judge. And that fear is valid. And a lot of that fear is presented by the abuser. So that victim might never, ever see a judge or might never be arrested by ICE, but the abuser is constantly making this threat. Victims of human trafficking, victims who are trapped in labor trafficking situations, this is the #1 threat that they receive all the time. If you don't keep working for me, I am going to contact the authorities and get you deported. Separation from friends and family, social and economic isolation, cultural differences, lack of resources for survivors filing for immigration benefits. Just to give you an idea, in Rhode Island, there's only 4 agencies, 4 nonprofit organizations that are authorized by the Department of Justice to represent victims to represent immigrants in their cases. And out of the 4, only 2 are representing victims, who is Dorcas International Institute and Sojourner House. So we are the only 2 agencies in the state that receive funding and are authorized to represent these victims. So, and before Sojourner House had this program, it was only Dorcas. And so that shows you that the lack of resources is so vast. And I mean, we are very busy. We take about 60 new cases every year. My open caseload is over 200 cases at any given time. And it's only 2 of us and 1 person that helps like 5 hours a week. So when I started the program, I would get a case and I would get a file within 2 or 3 weeks. Right now, we get a case and we have to triage. We have to see what is urgent, what needs to be filed right away. And on top of other things, like if we need a request for more evidence in a certain case. So we have competing priorities in these cases. And even though we try to help as many people as we can, they have to wait a little bit. So no, we're hoping to increase the program, to increase the capacity so we can help more people. And criminal abusers know this vulnerability and use it to keep victims from reporting crimes. And this is one reason why one of the benefits was created in the early 2000s, because lawmakers knew that a lot of victims were not coming forward reporting the crimes because they were afraid that they were going to get deported if they came forward. All right, so this is the list of potential immigration options for victims of crimes. We have the Self-Petition under VAWA, which is Violence Against Women Act. We have the battered spouse waiver, removal of the conditions in the green card. We have the U visa, the T visa, asylum, and other options for children. I'm going to go one by one, and the purpose of this is for you not to become expert on immigration law, but just to give you an idea of what's available out there. And when you get these referrals for the evaluations, you have an idea of the background, why this is needed. Also, I always encourage practitioners to reach out directly to the case manager or the legal advocate helping the victim, whether it's an attorney or someone at Sojourner House, and get more information about what kind of case is going to be filed for this victim, because the information in the report is going to vary slightly, but the variation is very, very, very important. So to give you an idea, for a T visa case, for a trafficking visa, we don't need so much information about the past trauma, because a lot of these victims have compound trauma. They have had suffered from their childhood until they became adults. So I know that a lot of information might sound relevant, but immigration only wants to focus on the trafficking portion. What happened, what kind of effect it had on you, what would be the outcome if you're deported. So to save you time and to save us time going back and forth, trying to edit the document and just highlight the important part, just talk to the practitioner and be like, what is it exactly that you need? Most of us even have templates that you can use and get some information out of it, so you don't have to reinvent the wheel. All right. So to understand how these benefits are applicable for victims, let's go back a little bit and understand how a family-based immigration petition works. So for someone who got married, one person is undocumented, the other person is a U.S. citizen or legal permanent resident. That's what this is, the LPR. So let's imagine there is no abuse, they just got married and they want to apply for benefits. So the basic steps is that the the petitioner, whether it's a U.S. citizen or the legal permanent resident spouse, has to file a form called the I-130. If the person is in this country, if they came with a visa, or they came with a parole, or they came legally, meaning they didn't cross the border, they came legally and then they overstay or whatever the reason is, they are able to apply for adjustment of status to become a legal permanent resident, which is to obtain the green card. So in this case, the petitioner, who is the legal permanent resident or the U.S. citizen, initiates the process, controls the petition, and can withdraw the petition at any time. And this is what's important. They can withdraw the petition at any time. I have a client whose abuser has filed 3 times an I-130. All 3 times he has withdrawn the petition, and then they reconciliate, and then he asks for forgiveness, and then he files again. Number one, they are very, very expensive, and abusers are willing to go as far as losing the money, and just in order to keep the control in the victim. So by doing this, when the petitioner withdraws the I-130, then when there's no I-130 pending and there is an I-485 pending, that means by this being gone, this will be denied and the person will be put in deportation proceedings, because now you have no reason to adjust. I wouldn't say no reason. They don't have any petition pending to make this adjustment of status approvable. So I'm going to give you an example what we do in cases like this, when the abuser either don't want to file or withdraws the petition or becomes abusive before the I-130 is adjudicated. So this is my first example. These are all cases that were assisted by Sojourner House. I'm just changing the name and the country of origin. So Claire came to the United States 8 years ago from Barbados to work on a work visa. She overstayed and she remained here living with friends. She met her husband, who is also from Barbados, but he is a U.S. citizen. And 6 months after getting married and moving in together, he became abusive. He always promised to file immigration papers for her, and they even visited an attorney to consult about their case. He broke her ankle during one altercation. He threatened to call immigration and get her deported if she called the police. He never filed the immigration papers for her in order to keep controlling her. So this sounds very similar to what I was saying before. He never filed. She never called the police. We didn't have any police report, but this is what we were able to do for her. So because she met the criteria, she was married to a U.S. citizen. She entered the marriage in good faith. And this is very important because immigration wants evidence that that person married the abuser or the U.S. citizen and legal permanent resident person in good faith, meaning I wanted to establish my life with you, and the reason is because I love you and not because I wanted papers. They have to demonstrate that they resided together. They have to demonstrate that they were battered or subject to extreme cruelty by the spouse during the time, and that the person is a person of good moral character. So, one really important comment I want to make here is this about the extreme cruelty. The reason why this language is included in the law is because we know that domestic violence is not just physical, it's not just sexual. There's a lot of emotional, psychological, verbal abuse that happens, and that is what's considered extreme cruelty. It's very hard to prove because there's no police report, there's no hospital records. So what we have to do is we have to rely heavily on the declarations from the victim. The victim has to be very, very detailed in their declaration about how they met, who proposed, who was present during the marriage, what did you do after the marriage, what has happened during the time that you lived together. So they want to know the good, the bad, and the ugly, and they want details. So I usually tell victims, I need to know everything. And it's sad because these are one of the cases, this is one of the type of practice that I cannot be trauma informed. I unfortunately have to almost re-traumatize the victim because it's like, okay, tell me more, and then what happened, and then what happened, and then what happened, because I need the details. So a lot of my clients relive their abuse by writing this declaration, and it's extremely hard, and that's why it's so important that they get counseling and therapy, because it's hard. This is a really, really difficult process for them, because that would be the only way to demonstrate the abuse. Now, if the person has a couple of police reports, we still have to give detail, but it's almost like refer to the police report, refer to the police report. Okay, they have to demonstrate that they resided together, and this can be a challenge when it comes to evidence, because a lot of the times abusers don't allow the victim to have anything on their name. First of all, you cannot put your name on a utility bill without a social security. You might be able to open a bank account, but if the abuser doesn't want you in the bank account, that's not going to happen. So we have them get, maybe you went to the doctor and your address is there, or maybe someone sent you a Christmas card and you saved the envelope. So we have to get very, very creative. And in regards to being a person of good moral character, what immigration wants to see is that this person didn't commit a serious crime within the most recent 3 years before filing. And this can also have a caveat, because we have had cases where the victim was charged with shoplifting, and that is a crime. That it's a crime of moral turpitude, actually. But if we're able to demonstrate that the crime was attached to the abuse, then immigration can see it as a contributing factor of the abuse. To give you an example, that client with shoplifting charge, she was married to a U.S. citizen abuser, and he was an alcoholic, and he didn't have any money to buy alcohol, and he said to her, you need to go get me a bottle of vodka from the liquor store near the house, whatever it was, or I am going to beat you up. And she knew that he had done it before, so she had no money. She had to go to the store. She tried to steal a bottle of vodka. She got caught. She got arrested, and she was, I think she was giving like community service or something like that, which is still a conviction. But we were able to attach that to the abuse, so that didn't affect her case. Sometimes abusers get the victim arrested as well during a domestic violence incident. So if it's a dual arrest, we are able to show that the victim got arrested because she was either in self-defense or it was just part of the dynamic. So those are usually, it's a little bit of an uphill battle with immigration, but we're able to get that. So the benefits of a VAWA self-petition is that the applicant doesn't need the abuser to file. Actually, the abuser doesn't even need to know that she's filing, because these cases are confidential, and immigration keeps these cases in a completely different database from any other case. So nobody has access to these cases. Not the abuser, just the attorney of record and the victim. Like I said, it's confidential. We don't even have to disclose where the victim is residing. I always put our address as the client's mailing address and physical address. There's no filing fee. If we're able to do a VAWA one step, meaning that we're able to file the oh my gosh, it's for the application for adjustment of status, then we're also able to apply for employment authorization. So within 4 to 6 months after applying, the victim can get a work permit. That means they can get a driver's license, they can open a bank account, they can get an apartment lease, they can start building credit. They might be eligible for certain public benefits if they have children, and then they are able to apply for the green card. And they can also include the children as derivative applications, even if the children were not abused, and even if the children are over the age of 18, because for immigration purposes, a child is anyone under the age of 21 that is unmarried. Okay. This is another type of cases that we handle at Sojourner House. As citizen of, I just want to give a quick, kind of attach the type of VAWA cases that we do, like the self-petition, to the possible evaluations that we have. So when the victim has suffered only extreme cruelty and no physical abuse, that's when the evaluations come in so handy, because an evaluator can apply the test and do the questionnaires and everything to determine whether the victim has any kind of mental health issues, and by affirming that this person has depression or anxiety, PTSD, whatever, that is just going to beef up their case, and we're going to be able to convince immigration that yes, this victim, not only is she saying that all this happened to her, but this was the consequences of it. So having an evaluation is extremely, extremely helpful for this type of cases. This other case, CBD was a citizen of Morocco, and she met her husband through a friend in her hometown. Her husband is a US-born citizen who converted to the Islam. He wanted to marry a practicing Islamic woman. He filed papers for her, and he brought her to the United States to live with him 2 years ago. She obtained her provisional 2-year green card upon entry. So just a quick pause. When someone is been married to a US citizen for less than 2 years, when they get the green card, they are going to get a 2-year green card. And the reason why immigration does that is because they want to make sure it wasn't a fraudulent marriage or a sham marriage. So by giving a 2-year green card, then before that 2-year green card expires, then they have to file a petition to remove the conditions on the green card jointly with the spouse. So they both have to sign the application. They both have to send evidence that they live together. So that's the opportunity for them to send birth certificates of the children born in the marriage, or what kind of financial assets they have together, joint lease or mortgage or bank accounts, or any evidence to show, like life insurance, car insurance, health insurance, everything that you can show that you have together that proves that your marriage is valid. Okay, so she became pregnant with her first child, and he refused to bring her to the doctor because he never put her under his insurance. He did not allow her to go out to buy groceries or visit friends. She didn't have a house key. He was mentally and emotionally abusive. She had to leave him, which means he cannot file the joint petition to remove the conditions on her permanent residence. So by him not being present, she had to file by herself. That's why there is a waiver requirement. So by filing under VAWA, the battered spouse waiver requirement, she is able to show that she's filing on her own because she's a victim of domestic violence, because she's a victim of battery or extreme cruelty. We still have to show all the other evidence that I mentioned before, that they lived together, that they had finances together, or we need to file an explanation why those documents don't exist. There's a caveat for VAWA cases that says, they are held to the standard of any relevant evidence. So if you have any evidence that might be relevant to the case, even if it's not a primary evidence, for instance, we don't have a joint lease because he never wanted to put me on the lease, but we have letters from our neighbors saying I live there. So that letter would kind of replace the lease, because that shows we were living there, and this is the explanation why I'm not on the lease. So we kind of have to corroborate with some sort of evidence so that the victim is able to qualify for these benefits. All right. The next type of case, we're talking about U visas here. Marlene came from Mexico 10 years ago because of gang violence in her hometown. She met her husband, who's also from Mexico, and 2 years later, they got married. Her husband became an alcoholic and would beat her up every time he was drunk. She wanted to call the police, but was afraid because she has a deportation order. They are both undocumented. Marlene is here with her daughter, who also crossed the border with her. Ultimately, she finally called the police, and her husband was arrested for simple assault. So I think I mentioned before that the U visa was created because lawmakers realized that a lot of victims were not coming forward reporting the crimes committed against them because they were afraid of deportation or afraid of the police arresting them. So this kind of created a bridge between community and law enforcement, and because the victims were coming forward, they were going to be rewarded with protection. And this protection was in the form of a U visa. So by the victim receiving protection, then being afraid of deportation was no longer a problem. So some of the cases are, the requirements. So in order to qualify for a U visa, the victim has to be a victim of a specific qualifying crime, and I have a slide on what the qualifying crimes are. They have to demonstrate that they suffered substantial physical harm or extreme emotional abuse from the criminal activity, that the crime occurred in the United States or violated U.S. laws, that the victim possesses information about the criminal activity, and the law enforcement has to certify that the victim was helpful, it's being helpful, or will be helpful. So, how does the psychological evaluation comes into play? So if the victim suffered, if it was a horrible crime, the victim lost a limb or got disfigured, then it's pretty easy to show that the person suffered physical harm. But if it's a domestic violence case and it was a simple assault case, it's kind of hard to show substantial physical harm, but we know the emotional abuse, that they suffer extreme emotional abuse and that it's there. So an evaluation would definitely emphasize that this victim suffered extreme emotional abuse from that crime, especially if it was not just a one-time assault. It has been happening for a very long time. It's easy to demonstrate that. Okay. So these are some of the qualifying crimes. We have domestic violence, sexual assault, all the way from manslaughter, felonious assault, perjury. Also, human trafficking is here. Even though there's a specific human trafficking visa, sometimes victims don't qualify for the T visa for whatever reason, so that we're able to get him a U visa. The only problem with the U visa is that this talks more about the law enforcement certification. We have been able to establish great relationships with the police departments in Rhode Island. So it's really easy for us to obtain these certifications. When I started the program 8 years ago, a lot of these departments did not know what a U visa was. It took a lot of convincing for them to even look at the case. But like I said, we have been able to develop this relationship, and it has been wonderful. The only problem with the U visa is only give 10,000 U visas a year, and the fiscal year starts on October 1st. Right now, I don't have the latest number, but last time I checked, there's over 250,000 people applying for a U visa. And if they only give 10,000 a year, you can do the math. I have victims who filed in 2015, they're still waiting for a U visa. The cases that I'm filing right now, I'm telling the victims, you are not going to see any benefit from 7 to 10 years. If that, I actually stopped giving people a timeline because it always gets pushed further and further, and I don't want the victims to feel like we're not doing anything for them. We are, but unfortunately we cannot accelerate the process. But when and if it gets approved, these are some of the benefits. It doesn't matter what the status of the abuser is. They can be undocumented, they can be documented. It doesn't matter. They are able to apply for a U visa. This is helpful for victims who are living with a U.S. citizen, legal permanent resident abuser, but they are not married. So by not being married, they don't qualify for the VAWA self-petition unless we can prove common law marriage. They get a non-immigrant status for 4 years, they get the work permit for 4 years, and then they are able to apply for the green card if they are eligible 3 years after having that work permit. So it's great. These U visas usually forgive deportations. They forgive if someone didn't show up for a deportation proceeding or in front of the judge. Even minor crimes it can forgive. So because it's so generous, there's so many people applying for this because there's no other option for them. For someone who already has a deportation order against them, it is so hard to reopen those orders. So they usually go the U route if they qualify because they know it's pretty easy to get the case reopened and terminated after. This is about a T visa. Marina was from a very poor family in a village in Guatemala. A town benefactor who was a legal permanent resident born in Guatemala convinced Marina's mother to let Marina come to the United States with him under the false promise of a better life and education. Marina was smuggled through the border at the age of 13, and the very same day she arrived, she was forced to be the man's mistress. She was forced to cook, clean, tend to him. She only did 1 year of school, and she couldn't tell anyone of her situation because he threatened her to hurt her family. She was subjected to rape and beatings. So in the surface, this might look like a domestic violence case. When this victim came to see me, she came because she thought she was a victim of domestic violence. When I did the assessment and I realized that she had come here under fraud, someone promised her to give her life, education, learn English or whatnot, and then under force and coercion, she was kept in that situation. I knew she was a victim of human trafficking. We pursued the case. We contacted the state police. We got the state police to investigate because they have to report the trafficking. So we complied with what we did, and then the state police was extremely interested in this case. And fast forward 2 years after we contacted, this person was convicted of child molestation and is still in jail. I think he's still in jail. So not only were we able to get this victim legal status, but she also got justice because we were able to identify her as a victim of human trafficking. So in order to qualify, they have to be a victim of severe form of human trafficking. It can be in the form of sex trafficking, labor trafficking, or both. She or he have to be physically present in the United States because of trafficking. So even if they have been in the United States before and then they became trafficked in a labor situation or sex trafficking situation, if we can show that they are still here because now they're traumatized, now it's hard for them to, go back to their countries and get services there. So if we're able to say they're here because of trafficking, then they qualify. They have to comply with reasonable requests in investigation or prosecution, and that can simply be, I am reporting the crime, what the department or HSI or state police or whoever is handling the case, what they do with that information is none of our concern. We are complying, we are doing what you told me to do, which is report the crime. A lot of times police decline to investigate or prosecutors decline to prosecute because they might not have sufficient facts, but that doesn't mean the victim wasn't a victim. And demonstrate that they will suffer extreme hardship if removed from the United States. So again, this portion right here is where the psychological evaluation will come in handy, because if we're able to demonstrate all the trauma that this victim has experienced and all the consequences from it, then if they are removed to their home countries, which are usually countries that don't protect victims, then they will suffer extreme hardship. The benefits are very similar to the U visa. The difference is that because not everybody qualifies for this, if someone applies, they might get the T visa within 2 years. So it's a little less of a waiting time. And again, after 3 years of having the work permit, they can apply for the green card, and they can give the benefit to derivative family members. For that girl that we helped, Marina, because she was under 21 when we filed, then we were able to bring her mother to the United States with a T visa. And actually her mother was a great key witness in the case, because then she was able to say, yes, that's what he promised, and that's not what he did. Okay, so let me... Okay, this is in regards to asylum. Gina is a Central Asian woman who came to the U.S. accompanying her husband, who was completing a PhD at a local university. He holds a student visa. He abused Gina mentally and emotionally for months. Gina decided to seek refuge at a domestic violence shelter, but she is now afraid of going back to her home country because as a Muslim woman, she will be condemned for abandoning her husband, who is now back in her home country. So we filed this asylum case, I think was in 2014, and she was granted asylum because she was able to demonstrate that she was part of a particular social group, in this case married Muslim women who don't want to be in an abusive relationship, and she was a protected class. She was afraid of going back to her home country because she feared that she was going to suffer future persecution. And when we filed this, there was a lot of case law that was giving gender-based violence as a protected ground. Okay. Unfortunately, in 2018, then Attorney General Sessions took upon himself to reverse a lot of this case law by saying that a private actor cannot be considered a persecutor. So this shut the door for a lot of domestic violence and gang violence victims, and we have had a lot of uphill battles, and there's a lot of organizations nationwide filing lawsuits and class actions and injunctions and things like that, trying to open a window for these victims, because the asylum law before Sessions made the decision was very clear. If the government cannot protect you, if you can demonstrate that you are being persecuted because of your gender, and you either suffer past persecution or future persecution. So it was a little easier to demonstrate that you would qualify. That kind of went away in 2018, but slowly has been rebuilding. We actually won an asylum case last year, was a little similar to this, from a woman in Guatemala. So it is possible. They're hard. They're very, very hard. And we are representing a handful of victims in immigration court, because again, these victims come here fleeing violence in their home countries, and then they are they come here, they are putting deportation proceedings, they don't have any papers, and they cannot afford private representation. So we're trying to help as many people as we can, but these cases are done in the immigration court in Boston, and they're extremely time consuming. We don't have the capacity, but we're trying to do the best we can. And obviously for asylums, having a psychological and physical evaluation, it's extremely important. You cannot basically win an asylum case without a psychological evaluation, because that is definitely going to show the past persecution or the fear of future persecution. All right, these are other options for children. We don't handle this as a Sojourner House. Dorcas International Institute does. They are the SIJ, the Special Immigrant Juvenile, and the Deferred Status. The Deferred Action for Childhood Arrival, the DACA, which is, we still don't know if it's gonna keep happening or not. This is probably not so much relatable to your work, but you know, it's always important to validate the fears and concerns. One thing I can say, if you're using an interpreter, make sure it's someone who is prepared and have experience working for victims, mostly because you want to make sure that the translation is accurate and it means what the victim is saying. There's a lot of idioms vary by country, so what thing might mean one thing in the Dominican Republic, it might mean a different thing in Guatemala, it might mean a different thing in Venezuela. So working with experienced interpreters is number one, and you know, if at the end, you know, making the proper referrals or assessments or whatever it is important, and always be in touch with the legal representative, because you know, that way you can work better and kind of narrow down exactly what is needed for their case. These are some of the community resources. I'm sure you're going to have a copy of this presentation. You can use it, and my information is here. I'm working from home right now. I'm only going to the office once a week when I need to see clients for signatures and whatnot, but I am available. You can really responsive via email if you need to reach out and let me know if you have any particular questions. Most likely we are going to be in contact when we have clients in common, but yeah, I'm willing to answer any questions, and I think I have this done under an hour. I hope it was helpful. I hope you got a lot out of it, and again, thank you for being a volunteer and for doing this for our clients. Have a great day. Bye-bye.